You have probably heard the term FISA discussed in the media. FISA stands for the Foreign Intelligence Surveillance Act. While many presume that it only applies to foreign surveillance and investigating people and actions outside of the United States, it also governs surveillance and intelligence collection on U.S. soil. It was initially intended to protect Americans following the Watergate scandal, where government agents were used by the Nixon administration to spy on the Democratic National Committee. This legislation was then significantly altered by the USA Patriot Act after the events that occurred on 9/11. In a good faith response to that immense tragedy, Congress rushed to give certain agencies expansive new powers to fight terrorism and protect our national security. But when they did so, they also gave the federal government extraordinary powers to surveil us all. In the past 2 decades, FISA has justified a variety of concerning programs that have collected information on Americans well beyond what Congress or the public ever imagined they had authorized. For example, in 1 year alone, the Call Detail Records program investigated 11 separate people, but ended up collecting information on over 434 million phone calls on over 19 million different phone numbers. And that's only one example. Other federal surveillance programs like PRISM, Stellar Wind, and the Hemisphere Project have all been used to violate the constitutional rights of people in the United States. Several reports from Inspector Generals and the Privacy and Civil Liberties Oversight Board have raised questions about the powers granted to government agents under FISA. These reports have revealed the failure of federal agencies to analyze whether their programs are constitutional and legally compliant, the lack of internal safeguards to ensure federal agents do not abuse their special powers, and serious errors during past investigations. Under normal circumstances, the Fourth Amendment requires the government to get a search warrant approved by a neutral judge. For the search warrant to be approved, the government must present enough evidence to convince the judge that the search is reasonable and not overly broad or invasive. The process is documented so that later, those accused of a crime can review the justification for the search and challenge whether the search was legal through their own attorney with evidence and witnesses. This challenge and review process is generally public. The opportunity to challenge and review the government's actions are built as a constitutional check and balance on the government's ability to search through our homes and papers, an extraordinary power that our founding generation understood could be abused. But FISA created an entirely new process for certain investigations. It established the Foreign Intelligence Surveillance Court, or FISC, where government agents seek permission to use their expanded surveillance powers. While the decision is ultimately left to a federal judge to decide, this process is missing important procedural safeguards and is cloaked in secrecy. The government's justifications for surveillance is classified. Any questions asked by the judge making the decision and any answers from the government are generally not documented, but if they are, those too are classified, as is the judge's final opinion. None of this is ever meant to be revealed, not to the public and not even to the person who was the subject of the search, even after the surveillance has ended, and even if the surveillance is used to charge the person with a crime. In fact, until recently, no request to view the information the government used to justify FISA's search has ever been shared publicly during FISA's 40-year history. But if neither the accused, nor regular courts, nor the public can ever review the justifications used by the government to search, surely the process must be subject to enhanced congressional oversight to ensure that someone is checking that these searches are proper. Unfortunately, no. Only a small handful of lawmakers ever see any of these documents. And when they do, they are heavily redacted. Even then, they can never speak publicly about what they have seen or any concerns they might have. That means that these expansive surveillance powers granted to the government to use against its own people are not subject to any meaningful challenge or review by anyone at any point, even after the investigation is over. That lack of transparency, accountability, and due process protection presents a real danger to our concept of the rule of law. Periodically, the government's surveillance powers under FISA lapse and need new congressional authorization to continue. As news of the ways in which FISA has been used to justify flawed surveillance programs in the United States become increasingly more public, certain congressional leaders and privacy advocates have tried to secure reforms to FISA as part of its reauthorization process. These reformers, from both sides of the aisle, have long sought common sense changes that would establish reasonable safeguards for the rights of people in the United States, while still permitting the use of intelligence operations necessary to protect our national security. But those efforts have been largely unsuccessful until now. After much effort by Republican Senators Lee, Daines, and Rand, and Democratic Senators Leahy and Wyden, the Senate successfully passed a version of the USA Freedom Reauthorization Act that included multiple safeguards to protect our privacy and constitutional rights. The bill has been sent to the House and will be voted on very soon. The legislation passed by the Senate, which doesn't include every reform that is necessary to fix FISA's problems, still represents a major improvement over current law. This legislation would end authorization for the NSA's constitutionally questionable call detail records program. It would require a regular court warrant for collection of cell site location and GPS information, and for anything in which a person would hold a reasonable expectation of privacy under Supreme Court precedent. It would limit the use of information collected through FISA surveillance in normal criminal or civil court proceedings. The bill would also limit retention of the large amount of information the government collects under Section 215 of the Patriot Act. And it would increase transparency and oversight of some FISA activities, while also strengthening third-party oversight of those activities, thanks to an amendment proposed by Senators Lee and Leahy. Thanks to the hard work of bipartisan advocates, including the Due Process Institute, as well as members of the public who made their voices heard by their lawmakers, the House of Representatives will soon vote on the USA Freedom Reauthorization Act. The bill the House will be voting on is essentially the same as the Senate's version, but hopefully with one good amendment, a much needed provision that would protect our internet and search engine history from government surveillance without any kind of warrant. Conduct that some courts have declared illegal, but that still continues. Will the House of Representatives pass these important measures to reform FISA and protect our internet privacy and constitutional rights? Or will they vote to undermine the bill's current protections by offering additional amendments that weaken the bill before its passage? We're working hard on your behalf to secure meaningful reforms to FISA. For more information about our bipartisan efforts to protect your civil liberties, including easy-to-read blogs, please visit our website or follow us on social media.